Hello, everyone. Welcome to this Friday's webinar presented by Hines Legal. I'm your host, as always, Chris Irons. With me today, also as always, Frank Higginson from Hines Legal. Welcome, Frank.
Hello again, Chris, and everyone. Thanks for joining yet again.
On this lovely, sunny and pretty fresh Friday afternoon, wherever you are in the world. Don't forget to like and share our webinar. As always, great to have your support. Please keep it coming along. And you can ask questions live today as well, as you can at any time. We have one or two there already. Today, though, Frank, we've talked a bit about nuisance owners. We talked a bit about nuisance owners a couple of weeks ago, which had a lot of interest, but quite rightly and quite fairly, a few people complained that what about nuisance committees and nuisance committee members? Yes. What about committees when they go rogue? So today, what does that actually mean? What does that actually look like? And what can you actually do about it? Before we start, Urban Dictionary says that to go rogue is to cease to follow orders, to act on one's own, usually against expectation or instruction, to pursue one's interest. Does that about sum it up, do you reckon, Frank?
I think so. And probably one of the triggers for this webinar was absolutely everyone saying, well, I'm only a nuisance owner because I've got a nuisance committee type thing, which is fine. And the other one, I just finished Malcolm Turnbull's autobiography. So I am a big reader of political books. And probably one of the things that was really interesting to me at the back end of that was he was getting criticised for trusting a lot of people. And in context, he said the difficulty with the difference between politics and business is that in business you can pick who you go into business with, but in politics you can't. You have them thrust upon you by the electorate. And in that sense, it's no different, I think, from a committee perspective, where a bunch of people put their hands up. They might be from different factions inside the body corporate. They might all have their own agendas. Might be to get the chairmanship. It might be to have the backyards tiled. It might be whatever it is. So it's sort of an interesting parallel. And it's just those disparity of opinions and peoples and agendas that probably causes some of the things we're going to talk about today.
Absolutely. Really good analogy, I think, Frank. But in order to figure out what going rogue is and what you can do about it, I think we have to go back to a bit of a first step, which is what is a committee? What is the committee's role and responsibility? Because you've got to know that, because then you'll know what it's going rogue from, if that makes sense. So this might be a bit simplified for a few people, but it never hurts going over a few of the basics. So the committee is the subset of the broader body corporate, and it has the day-to-day management role of the scheme. They are elected positions. Sometimes you can be appointed to a committee, but largely elected. And one way that I often describe a committee when I speak at events is to think of it a bit like what happens in Parliament, using your political reference again, Frank. So in Parliament, you have all the members of Parliament, and then from that, a much smaller group is the Cabinet.
And the other one, the other one I use, mate, it's like the board of directors of a company. All of the owners are shareholders. The directors are the ones that make the decisions for those shareholders, and that's effectively the parallel with a committee.
Exactly. It's a really good analogy. So you have this group who are chosen out of the broader group, and they're chosen to represent the interests of everybody else and make those day-to-day decisions. In Queensland, under Queensland legislation, the body corporate, and therefore by extension the committee, must act reasonably in everything that they do. That always varies from case to case. When it comes to a committee, there are a lot of requirements about how they're appointed and how they're formed. There are a minimum number. Eligibility. There's a minimum number, isn't there, Frank? Minimum 3?
Maximum 7.
Yep.
And I suppose, again, in Queensland, one of the key things is that there's sort of executive and ordinary members. There's 4 ordinary members, and then there's chairperson, secretary, and treasurer. One person can hold all 3 executive roles. So if I was voted in chairperson, secretary, treasurer, and there were 4 ordinary members, we've only got 5 members of the committee, but that's a validly formed one. But I don't get 3 votes, I only get 1.
Yep. We've got a comment from somebody there who's comparing our analogy, talking about all owners being all investors. And that's probably a really good point to make too. Under Queensland legislation, I'm sure it's the same everywhere else. It's very, very heavily prescribed for how a committee is meant to do what they do. Things just don't happen randomly in a committee, do they, Frank? Nothing happens by accident, because government adjudicators have consistently recognised that there's a need to regulate how committee members execute their functions, isn't there?
Yeah, and it's probably, I think from a Queensland perspective, more around constraining certain behaviours. So what we've got is restricted issues or restricted matters if you're under BUGTA. So committee members can make a decision of the committee is a decision of the body corporate, other than when it's on a restricted matter. So simple things are issuing levies, for example, changing bylaws, things that are reserved for decision making at general meeting only. But other than that, sort of inside that framework, how the committee then runs itself is up to it. So one of the things that's always interesting is how committees meet. And we'll talk about this in a minute as well, is that there's no statutory minimum or maximum number of committee meetings. You can have one a week, you can have none a year. It's up to each. Yeah. There's nothing in the Act that says this is what must happen. There's a whole bunch of stuff around what you can't do, but there's not necessarily a whole lot of stuff about how you must run your particular committee. And I suppose that's where, for want of a better phrase, Chris, the roguishness might come from time to time, in terms of expectations being different from the committee versus the public at large, or their owners, their owner group.
No, that's right. That's right. So, and that kind of points towards the model that we're talking about. And the model and what the legislation contemplates is that you have a committee, and that oversight for the committee's functions rests with all owners as part of that broader body corporate. But that's never as simple as it sounds or looks, of course, which leads us to going rogue. So what does that look like? What if we're to say a committee member or a committee is going rogue, what does that look like? Well, Frank and I had a go at coming up with a list of what that actually means. I don't think this is exhaustive by any means.
Definitely not. This could be the rest of the webinar talking about the examples of rogue, for want of a better phrase.
So if these things are happening, then chances are your committee is or has gone rogue. So at its broadest level, the committee not acting in accordance with its legislated obligations. That's the broad level. And at a micro level, it might be things like poor behaviour. That can mean any number of things. Poor conduct, inappropriate communication, or no communication with owners and contractors. So a classic example there is no committee minutes, but you know for a fact the committee is meeting, or vice versa. You don't know the committee has met, but then suddenly randomly some minutes appear. Well, where was the notification about the meeting? Committee decisions not being made at all, or not being made properly. One of the classic ones of a rogue committee or a rogue committee member, Frank, one committee member, usually that's the chair, acting unilaterally and not as a group, isn't it?
Absolutely. There's no ability for any committee member to make a decision for the committee. So even when you get into, I suppose, subcommittees, which is definitely not a legislated term. So it's fine for a committee of 7 to say to 3 of the people, how about you guys and girls go away and look at this particular issue and come back to the group as a whole with whatever your recommendation.
It's actually really good governance to do it that way.
Yeah,
isn't it?
Absolutely. But it's not those 3 people that would then make the decision. So, and I think probably, and I suppose that's the thing with these things, you can have up to 7 committee members, you can have to have 3. It is far from uncommon for there to be one particularly motivated person who rules the roost and has, this is where a lot of the things come from that we deal with, patsies, for want of a better phrase, that sit there and just do what they're told and run along with whatever that particular person wants to drive. So
there's that classic Seinfeld episode, isn't there, Frank, where Jerry and Elaine go and visit Jerry's parents in Florida.
Yes.
Jerry's father is running for president of the Condo Society and wants to install Kramer as a puppet regime.
Yes.
Body corporate world in a nutshell.
Yes. Yes, truly international.
One of the dead giveaways for a problematic committee for me when I was commissioner was when we'd see emails come in and the email address was chairperson at or chairperson for at blah blah, and what that usually told me and my staff was that this person had a sense of entitlement, but also a sense that because they were chairperson, their will would carry the day, regardless of what else. It's not the case. Anyway, where did we get to on our lists? So we talked about acting unilaterally, elections not being properly held or the results being ignored. That's pretty rogue.
We had a dispute not that long ago where there was 2 committees. We were elected. No, we were elected. So it was just, again,
it's pretty frequent. That
yeah.
sort of dispute is very frequent. Actually, you have 2 parties, 2 groups of people who say, we're the committee. No, actually, we're the committee. And you find adjudicators' orders who are actually finding some ways of explaining them. I saw one recently where the adjudicator called, I think it was Group 1 or Group 2 or something like that throughout the order, which is probably a pretty good way of doing it.
The Judean People's Front, mate.
Yeah, exactly. Ineligible people being on the committee and nothing being done about it. And Frank, really good example of that is management rights associates.
Absolutely. And there's a question there in a sense from Rianne. What is an associate? So in Queensland, not all lot owners can be on committees. If you're a lot owner and you have an interest in the management rights business, you are automatically elected a non-voting member of the committee, and that would be the same if you were the body corporate manager. And I've literally got off the phone from a body corporate manager just before where the only people on a particular committee are associates of the resident manager. So that's going to become a very ugly matter very quickly. How it hasn't been dealt with in the previous 5 years is beyond me. But, and I suppose we're talking about solutions in a minute. So associates, fairly wide-ranging definition, direct family relationships, direct employment relationships, and probably the catch-all at the end is an associate, someone who's accustomed to acting under the direction of the resident manager. So that can capture a wide range of things. So it's really...
But yeah. Rianne's question is interesting. Can the committee member live in the caretaker's lot? Well, that of itself is not a problem. No. Where they actually live is not the issue. It's how they are acting or under whose authority they are acting. Yep. That's right. Yep. A couple of other indicators of going rogue. Not declaring conflicts of interest is a big one. So just to clarify, conflict of interest provisions only apply at committee level. There is no conflict of interest at a general meeting. Everyone's conflicted at a general meeting. Not acting in the best interest of all owners and occupiers, not enforcing bylaws or inconsistently enforcing bylaws. So classic examples of that is where you have an alleged bylaw breach and the person who is allegedly breaching is a committee member, but shock horror, the bylaw isn't enforced against them or isn't properly enforced. Yeah. That's a common one. As I said before, not holding committee meetings or holding them inappropriately, even though Frank said that there's actually no obligation to hold a committee meeting, probably less so that and more so not holding them properly. Ignoring decisions taken at a general meeting level. So a decision's been made at a general meeting and the committee decide that they'll ignore it or they'll just do something different. Acting against code of conduct provisions for committee members, and then finally, an obvious giveaway, illegal activity. So money mysteriously going missing, for example. That's usually a dead giveaway.
It is. Suddenly started charging bodies corporates fees to do things that aren't approved, because as a committee member, they're all volunteer positions unless you're actually voted in on that basis for some sort of remuneration. So that's another giveaway.
Absolutely. So what's the legislative and legal position here? Well, just a couple of quick facts. Committees are formed at general meetings or extraordinary general meetings if it comes to that. Casual vacancies can and indeed must be filled. So if you start out with 7 committee members at the start of your financial year, you must continue to have 7 members throughout. As I said before, as Frank said before, some very, very prescriptive eligibility requirements, and a very, very common source of dispute is whether or not somebody is eligible. We talked about the need to declare a conflict of interest. That's a legislative provision. It
is, yep. Yeah, and the difficulty with that is that it's a personal obligation on the committee member themselves. So it's not for me to say to you, Chris, you've got a conflict, you can't vote on this issue. We can certainly have that conversation, but I can't stop you voting if you're not going to declare a conflict. If you sit there and say, well, I don't, and I am going to participate in the decision, then here you go. Then that's the stuff that it can expose that particular decision to challenge later on.
Yep, that's right. That's right. What else does the legislation say? Committee members are indemnified up to a point, aren't they, Frank?
Yes, for acts taken in good faith and without negligence. Now, I mean, you've always got to have, not always got to have, every body corporate should have office holders insurance in place as part of their package, so that if there was a claim against the committee, that they're protected or indemnified from an insurance side of things. But, you know, and I suppose where I get to is, comes up pretty regularly in the context of, you know, you can have buildings, you know, and then the disputes we're talking about, the buildings might have 100 units. They might be worth, well, literally tens of millions of dollars, maybe even hundreds. And the sole qualification to get on the committee, to get involved in the management of that particular building, is doing that at a general meeting. But, you know, so there's a criticism there in the sense of there's people with no qualifications, experience or competency putting their hand up to do these things. And the converse argument is that to the extent you're going to require some form of qualification, what actually is that? Will that lead to better decision making? And more importantly, I think, and I suppose, Chris, you could speak to this in terms of your history, one of the policy ideas behind the BCCM Act is allowing everyone to get involved in the management of their own investment. So to the extent that you put a bar on people being involved, that's almost discriminatory in a sense itself. So I think we're never going to have a requirement for any formal qualifications or training, and that means that the bar can be relatively low in terms of behaviour at times.
Yep, well said, Frank. Just a couple of final things, legislation and legal position. If a committee can't be formed, either at the general meeting or the subsequent adjourned general meeting, they must enter into what's called a Part 5 agreement. And that Part 5 agreement basically stems from the section of the legislation under which it's formed. And in that case, a body corporate manager takes on the role of the committee. That's not a situation that you want to get to. Nobody really wants that situation, but that's the default position that the legislation gives. So if a committee can't be formed, that happens, and we are currently in discussion with a few body corporate managers to provide that Part 5 assistance at the moment.
It is, because what that does is sort of, from a body corporate manager and from a lawyer perspective, we're normally advisors. We don't actually make decisions for clients. We'll say, well, here's your choices. We can make a recommendation, but ultimately it might be your call. A Part 5 is where someone's actually making the decisions as the committee for the body corporate. And I suppose from where we're sitting, who would be a better decision maker for a committee than the former commissioner for body corporate and community management, Chris Irons? So we're working with. There you go.
What can I say? Seriously. And following on from that, the other possibility is we've talked about this in previous events, Frank, but for completely dysfunctional bodies, corporate committee or not, an administrator is the other option. And then finally, committee members can be removed by ordinary resolution at a general meeting. You don't have to provide reasons for that. You can just put up a motion that John Smith be removed from the committee and Joan Smith be appointed. But a cautionary sort of statement to make there, and one that I make all the time. When I was commissioner, people would say all the time, oh, I want to remove the committee. I want to remove the committee. I want to remove the committee. That's great. Do you have somebody to actually replace that committee and that committee member? There's no point going down the path of replacing a committee if you don't have somebody decent to replace them. Before we get on to what you can do and my best practice steps, couple of questions there. Rian, do committee members lobbying and holding proxies fall into rogue? Don't agree, Rian. There is this misconception, and Frank might have a different view, but there's this misconception that you can't lobby. No, you can lobby. You can lobby to your heart's content. Proxies, slightly different in that there are some restrictions on use of proxies at committee meetings. But again, I don't see that that's going rogue, Frank.
No, and I suppose it sort of comes back to that police state type mentality in terms of people are entitled to express their opinion, and they're entitled to ask others to support their point of view. So, and it happens pretty regularly. I suppose
It's a numbers game, Frank,
It
isn't
is,
it?
mate. It is. It is American
Look,
politics where there's no obligation to vote,
yep.
but a right.
And I know that sounds harsh when I say it, but it's the truth. People complain that they don't get onto committees or they don't get their motion approved. Did you have the numbers? No. Well, simply not liking an outcome is not evidence of going rogue. So just because you disagree with a committee decision doesn't mean the committee is doing the wrong thing. Probably should have said that right at the start. Yeah, it's a misconception that because I don't agree with the decision, therefore the committee is acting improperly. No, chances are they're actually acting entirely properly, but they've just made a decision that isn't in your interests. So be it. Yep, there it is. Well, what can you do? Well, step one sounds obvious, Frank, but step one, you've got to take an interest. You can't complain about a committee if you don't read papers and you don't vote.
And how
Simple
many
as that.
times have we had that conversation where clients come in wanting us to give advice on a decision that's been taken, usually at general meeting, and they haven't put in a vote themselves against it. It's only after the event. And that's just not a good look when you go to the Commissioner's office making an application and you didn't even participate in the decision in the first place.
Commissioner's office will ask that very question, Frank, and that will usually be the end of the matter if the answer is no. The other thing is put your hand up for committee. You mightn't get the numbers, you mightn't get your vote. Well and good, take it on the chin if you don't, but show your interest and be involved. So you can't sit on the sideline and complain about your committee if you're not willing to take an active interest in what's going on. You don't have to necessarily be a committee member either. You can assist the committee. So even if you're not elected to the committee, what about putting up your hand? You might have a particular skill set that would really help out the committee. You might, for example, be really good at graphic design and assist the committee in putting together some flyers for something. Help out that way. Step two, related to step one, exercise oversight. So monitor the decisions, monitor how things go, ask questions if you need to. Access records if you need to. Frank, anything?
Yeah, no, and mate, that's exactly what I'm just thinking of one particular matter where you're helping a new committee member to understand what her rights and entitlements are and what she should be doing in terms of corporate governance with respect to a long-standing committee where she's not quite sure that all the right steps are being taken. So it's sort of, and for me, these things, some say to clients all the time, it's very easy to get bolshy about things and get upset and start throwing stones. It's a much easier place to start from if you do it gently. So in these things, and this is the difficulty with this market, I suppose, and by market I mean the body corporate information industry, there's lots of opaque things out there. There's lots of different ways to interpret stuff. The Commissioner's office in Queensland is an extraordinary resource for information, and I suppose
do you think that's got anything to do with the commissioner who used to work?
So now you're plugging yourself, mate. It's unreal.
All right, I'll stop.
But it is. It's a spectacular resource, and I think a lot of the disputes we get in Strata is people going off half-cocked without actually knowing what they're going off about. So I think a big part of Strata is educating yourself around what should happen and what could happen and what your rights and entitlements are, and then approaching that in a non-confrontational manner if you're not sure that the committee's doing the right thing. So, hey guys, I saw this, and I'm not quite sure how that fits in the context of this particular issue. You know, it might be that they're replacing the lift. I don't know. Have you got 2 quotes? You know, it's just that sort of stuff rather than you're required to go get 2 quotes, go get it type stuff, which is sometimes just, you know, that instantaneously creates barriers, people's backs go up, and that's where the fights start.
Yep. Which leads very nicely to my step 3. Be respectful of the fact that committees are voluntary and therefore temper your expectations. I don't think you can expect same-day responses, for example. You can't expect instantaneous results because it's group decision-making. If you do have an expectation, communicate that to the committee and actually say, I would really prefer an answer within this time frame because I've got this demand upon me. Which then,
that lack of organisation on your part doesn't constitute an emergency on mine. That
very much so.
Style of response.
Yep, very much so, Frank. Step 4, if there is a problem, articulate it. Raise it with the committee and give them the chance to consider and reply. So you've gone through all of the other steps. There is a problem. not getting anywhere, articulate it, put the demand on the committee. This has not been done. I would like a response in 14 days. Please consider and reply, whatever the case may be. Which then leads to your final step. That's assuming the previous one didn't work or didn't work in the way you wanted to. You have to be prepared to take some action. So at this point, you've got to make a decision. Are you going to follow through with it, or are you going to leave it? If you leave it, the situation goes unremedied. But if you do want to do something about it, you have to remember that it might take a bit of time and a bit of effort. You can challenge committee decisions through my former office, the Commissioner's office. You can seek to remove committee members if you like, or you can seek to challenge the validity of committee members if you wish. Again, I come back to my previous point, you have to have suitable people to take their place. There's no point challenging if you've got nobody else putting up their hand, because eventually you're going to get to the point where you might need to have a Part 5 agreement, which is going to cost you a lot of money. So there are your best practice steps. We had a question beforehand, and it kind of touches on this issue, kind of doesn't. Non-structural renovations carried out within a lot. What does best practice look like when we consider do's and don'ts for owners and committees? So probably the best thing I can say there, first of all, clarify that it is indeed within your lot. Frank and I have seen plenty of instances where people do renos and assume it's within their boundary and it's not, or vice versa. So make sure you know where the boundaries are. Make sure you also know where common property begins and ends. Make sure you allow enough time for a committee to make a decision. So if you're wanting the committee to approve something, don't give them the request the day before you're about to start work. That's just not going to fly. You need to build in time. If they have a reasonable, make sure you've got all the information in front of you and present that to the committee. For example, if you're doing a reno and you haven't presented plans, how can the committee make a decision on anything if they can't see the plans or what's required? There's some of the basics, I think, about best practice. A couple of other questions or statements. Legislation requires amendment to require a committee to undertake meetings that body corporate has contracted.
Sounds like there hasn't been a committee meeting there for over 3 years by the sounds of it. So, and again, I suppose that would be an example of putting your hands up or finding other people to put their hands up to go on the committee and run it the way you want it run. And if the other owners don't support you in that endeavour, then you've got a choice to make. But whether you stay involved with that particular body corporate or building or rally the troops to get more people to think the way you're thinking and get the building to be run or the scheme to be run the way you want it run.
But if you're saying, if you're saying there's been no committee meetings at your building for 3 years, that's a problem, and you've got to decide if you want to take some action about that. And I would think that the action would be you need an administrator appointed, because it's too late now. You need somebody independent appointed to rectify things and get it back on an even footing. That's what an administrator does. Another comment, have been waiting 7 weeks to reply from committee, but a letter tabled but not noted in minutes. My first question, is there actually something in that you need a response on, or were you just making a comment? So are you actually waiting for something to come back? Was there an actual request in there? 7 weeks is probably too long, I would suggest, depending upon what it is. You would hope for an interim response. So I would say to you that you're probably in a position where you can go and say, I haven't received a response. I look forward to your response in 14 days. Otherwise, but you have to be prepared to follow through on that otherwise bit. Yep.
And I think probably the first rule of that Fight Club is not making threats about stuff you're not willing to follow through on, because the moment you say to someone, if you don't do this, I will, the moment you don't do the I will bit, any demand you make from that point forward is going to be ignored.
Yep.
So just really,
right.
There's a far lower standard of corporate governance in these things than people sometimes like, but it's a very fine balance between sort of enforcing rights and imposing obligations on people that are volunteers. So, and that's not to say that there's not committees that don't do the right thing. There absolutely are, but it's just trying to be really clear what it is that you're looking for and what you're entitled to, and what you're going to do about it if something doesn't happen.
My experience, Frank, and this might not go down well with some people listening, but my experience as Commissioner is that the vast majority of committees are sincere in trying to do the right thing by everybody. That's my experience. It's only a very small percentage of committees that go rogue. But when they do, it's a real problem. It's a real problem. It affects everyone. Things don't get done and it causes a lot of heartache. So hopefully today that's given a bit of perspective on the topic. We need to wind it up there. What I would say is if people have got queries about committees going rogue, that sort of thing, chuck them on the Facebook page as a comment. And look, if there's enough interest, we can always hold a sequel. We can add it to our list of sequels to hold.
Yeah. And mate, what I'd say in terms of those steps, probably, we spoke about sort of steps 1 through to 5 in terms of solutions. Step 5 is probably the legal proceeding type bit. One of the reasons Chris is with us is for the previous 4 steps in terms of what are the best practice tips, what are the ways to actually get engagement with your committee, and what we are doing is helping people behind the scenes to get where they need to go without formally appearing on the record. Because the moment legal letterhead appears, everyone gets a little bit skittish, and justifiably so. But you can be pointed in the right direction and given guidance to get where you need to go without the need for full-blown legal proceedings. So that's probably there's the best practice type stuff is Chris's role. The legal stuff will always be what we do, but there's a vast body of work before things need to get legal where Chris can help.
Absolutely. I'm going to very quickly answer 2 questions that have just snuck in there at the end. Would it be defamatory to tell the committee that they would be classified as rogue? I think that's very ill-advised. Frankly, Julianne?
I just think name calling doesn't help.
Yeah. I don't think that helps, no. I would advise against that. Question about having issued the Form 1 to a committee and nothing's been done in 14 days. Next step is to enforce that matter through the Commissioner's office. That's your next step.
So if the committee's not enforcing bylaws, you've got your rights to go and do that.
Through the Commissioner's office, yeah. That is it for today. Thank you, everyone. Seemed to be a bit of interest in that one. As I say, put your questions on Facebook. If there's enough there, we'll hold a sequel and we'll try and get through a few more of those. You can always come back to this and have a rewatch for some tips. Again, don't forget to like and share. You can register for next week's webinar online. That should be up now or will be up shortly. But otherwise, Frank, it's been a pleasure.
Yet again, mate. Thank you, everyone.
Thanks, everyone. We'll talk to you next week.
Have a good weekend.
Bye-bye.
Bye.